היה לי בזמן הדברים של תהילה את ההזדמנות להתחבט האם לעבור לעברית, אבל משיקולים שונים החלטתי להישאר עם האנגלית, ולא בשל אלה שבכל זאת יושבים פה ונוח להם יותר עם האנגלית, ולא בשל ההזדמנות לעשות practicing לאנגליש. אוקיי. So the procedural agreements in Jewish law, an expansion or a restriction. The subject of this lecture is the procedural agreement in Jewish law. Thereafter, I will call it PA, procedural agreement. Generally, a PA deals with the agreements between parties to a conflict that relates to the procedural aspects as opposed to the substantial aspects of the conflict. The PA brings about a deviation from the procedural rules that would have otherwise applied to the adjudication of the conflict. While current legal literature deals with the limits of the PA, the contents aspect, it seems that Jewish law deals mainly with the way by which a PA is achieved, the form aspect. For example, does one have to make a kinyan in order to effect a binding PA, or is this not a precondition? You can say that dealing with the limits of a PA examines the context thereof, but dealing with the way by which a PA is achieved, you are dealing with its form as opposed to its contents. The major example of the PA we find in the Mishnah in Sanhedrin. נאמן עליי אבא, נאמן עליי אביך, נאמנים עליי שלושה רועי בקר. רבי מאיר אומר, יכול לחזור בו, חכמים אומרים, אינו יכול לחזור בו. According to this Mishnah, although a father is disqualified by Din Torah to act as a dayan or to be witness, the parties may qualify him by the PA. As we shall see, the disagreement between Rabbi Meir and Chachamim relates only to the form aspect, but they both agree as to the possibility of the nomination of the father as a dayan or a witness. What is the relation between this sugya and the subject of Adam matne על מה שכתוב בתורה? The Rashba asks, how is it that Rabbi Meir accepts the possibility and the validity of נאמן עלי אבא, while he is of the opinion that המתנה על מה שכתוב בתורה, דבר שבממון, תנאו בטל. A condition against Din Torah, even relating to monetary business, is invalid. The Rashba doesn't offer an answer to this question and leaves it as a puzzle. See, אין בזה מקום אריכות. Maybe due to lack of time, or because it's too simple. We may offer more than one answer to Rashba's puzzle. I would like to present a solution using the distinction between procedural and substantial norms. Rabbi Meir perceives all substantial norms of Torah as binding, including norms relating to monetary business, and therefore one cannot bypass them. Procedural norms, however, are perceived as default regulations and are subject to the parties' power to make an agreement aiming at the employment of different procedures. Thus, they can be conditioned. Is that distinction relevant also to Rabbi Yehuda's opinion, which was accepted as the binding halacha, that maintains that a condition against Din Torah relating to monetary business is valid? We might say that Rabbi Yehuda perceives both procedural and substantial monetary norms as default regulations. This approach can also explain why Rabbi Meir and Chachamim both agree that the PA Ne'eman Alei Abba is valid, because it tends to change rules that are merely default. It now seems that any procedural agreement in Jewish law should be accepted as valid. Since the law allows a father to be a dayan of his own son, under parties' agreement, one can hardly think of any kind of a PA that will not be acceptable. So we may now understand the meaning of the word expansion in the title of this presentation. PA in Jewish law as an unlimited expansion of civil procedure. Isn't it surprising that prima facie Jewish law allows bypassing din Torah by PAs where other legal systems do not? As I mentioned, the disagreement between Rabbi Meir and Chachamim relates to the form aspect only of the PA and not to its contents. This is the meaning of the disagreement, whether the parties may regret their agreement or not. See, יכול לחזור בו, אין יכול לחזור בו. The Amoraim in the Babylonian Talmud and following them, the Rishonim, also regarded this sugya as relating to the form of the PA only. However, the Tosefta Sanhedrin brings a unique opinion of Rabbi Yehuda, who regards the contents of the PA, Ne'eman Alai Abba, as problematic. Following the disagreement of Rabbi Meir and Chachamim, Rabbi Yehuda's opinion is brought, claiming that a single judge should not sit to judge. Rabbi Yehuda Omer, Amar lahem, en yichidi dam. In other words, Rabbi Yehuda questions the validity of the PA as it contradicts the principle of hearing a dispute by a panel of judges. According to Vienna manuscript, in the square brackets, the question comes from the Dayan itself, who turns to the parties saying, en yichidi dam. It is clear that Rabbi Yehuda, understanding this PA as allowing the father to judge singularly. Bearing in mind Rashba's question relating to Rabbi Meir, a similar question may be addressed to Rabbi Yehuda, who rules that amatneh al davar shebimamon tna'o kayam. How can he question the validity of the PA Ne'eman Alai Abba? Should not this PA be valid as a tnai b'davar shebimamon, similar to any other monetary business? One can also ask a second question: why does Rabbi Yehuda not question the validity of the nomination of Ne'eman Alai Abba from the aspect of the disqualification of a relative to judge or be a witness? This disqualification is regarded as din Torah. What is the difference between the disqualification of relative, Abba, and that of en dan yichidi? I propose that the answer to the first question is that Rabbi Yehuda regards this PA, Ne'eman Alai Abba, as going beyond monetary business. The en yichidi dan norm, whether it is guidance or a prohibition, is not confined to the relations between the parties. It is directed to the Dayan. As Rabbi Ishmael says in the Mishnah, Avot, Al tehi dan yichidi, she'en dan yichidi, ela echad, namely, judging singularly treated as a pretentious behavior. Therefore, according to Rabbi Yehuda, agreement on a single judge is beyond the power of the parties. In order to permit a hearing before a single judge, PA is necessary but not sufficient. However, this is not Rabbi Yehuda's conclusion. As the following sentence in the Tosefta shows, אמרו לו, אין לנו אלא דעתך, וקיבלו עליהם, אין יכול לחזור. It seems that Rabbi Yehuda remains in his objection to Ne'eman Alai Abba PA, but offers a bypass. If parties agree to be bound by the judge's opinion, the PA is valid. One may ask, how did this formula solve the al tehi dan yichidi problem? As a matter of fact, the judge does act singularly. In my opinion, the answer is that acceptance of the judge's opinion is not regarded as a judicial process under the roof of din Torah. In the case of a din Torah ruling, the judge's jurisdiction emanates from the din, and therefore his ruling is binding upon the parties. Contrarily, when the parties undertake to accept the judge's ruling and act accordingly, the source of the judge's power is their mutual obligations and not the din. The judge's opinion merely fills in the contents of the parties' agreement. I should emphasize that even though the parties are taking the process out of din Torah, both the parties and the Dayanim are interested that the substantive law should be the din Torah. That is, that the Dayanim should strive to examine the case before them in accordance with the substantial din Torah. But still, the process is not conducted under the procedural rules applying to din Torah, and the Dayanim have nothing to fear from form if their judgment deviates from the Din Torah. This solution circumvents the problem, since by conducting the process outside Din Torah, the judges become arbitrators, accepted by the parties, and the rules of Din Torah do not apply thereto. As far as I know, such a solution may not have been readily adopted by other systems of law. I mean, inside the court. Yeah? It acts against the system both from substantive aspect, since the process is not conducted under Din Torah, and from the institutional aspect, as a process which is not conducted under the Torah is conducted within the premises of the court. This understanding of Rabbi Yehuda's opinion may also solve Rashba's question above regarding Rabbi Meir's opinion המתנה על מה שכתוב בתורה, אין תנאו קיים. We circumvent the problem of the condition being against the Torah if we adopt the understanding that נאמן על האבא is a process outside the Torah. It might be more persuasive if we could see any other source that support this solution. In the Yerushalmi in Sanhedrin, relates that the Yerushalmi relates the two persons approached Rabbi Yossi bar Chalafta, asking him to a judging between them applying Din Torah. He answered them that he didn't know Din Torah and suggested that they accept whatever he should decide. Here also Rabbi Yossi bar Chalafta desires to leave aside Din Torah and conduct an alternative process based on the acceptance of the parties. The course of action adopted by both by Rabbi Yehuda and Rabbi Yossi bar Chalafta show that they share the same solution where there appears to be a problem in conducting Din Torah process. That is, instead of referring to the parties to an alternative dispute resolution, they prefer not to send them away, but to use this invention of conducting a process before the Dayan that is not under the roof of Din Torah. As mentioned above, the purpose of the parties and the Dayan in adopting this solution is not to leave the substantive Din Torah, and the Dayan shall in fact strive to reach the judgment and that is dictated by Din Torah. We may offer two explanations for the motivation behind such invention as well as behind bringing the parties to agree on allowing the single Dayan be the judge. One is Yirat Adin, the fear of the judges that their decision might not be identical to the true Din Torah. There are a few recent researchers that argue that Yirat Adin has an important role in understanding several legal institutions. In our context, Yirat Adin explains why Rabbi Yehuda and Rabbi Yossi bar Chalafta were not deterred from conducting a different process other than Din Torah to solve their dispute. And B, keeping Jewish legal autonomy during such periods when Jewish jurisdiction and the right to conduct legal processes were threatened by enemies in certain historical circumstances, there was a clear interest to keep litigants within the Jewish court of law. Conducting a process before the judge was preferable than resolving the case in an alien or external court. At those times, when collecting a three judges panel may have been difficult, allowing a single Dayan judge the dispute was a better solution. Reverting to the second question posed above, relating to the disqualification of a relative, I would propose the following answer. Rabbi Yehuda regards this disqualification as aimed at protecting the interest of the parties only. Therefore, such a PA should be valid, since both parties rely on the father's integrity and agree to allow him to judge their dispute. In the Yerushalmi, on our Sugya, there are two additional discussions that deal with the contents aspect of PAs. Since time doesn't allow, I shall not read them out. The image learned from what we have seen this far and from these discussions in the Yerushalmi may serve a basis for two possible views. One, that the impression that may have been created that Jewish law allows an unlimited freedom to make a PA with any concepts or contents the parties might agree on is inaccurate. The second, that Jewish law had an interest during certain periods in history in extending the jurisdiction of the courts using PAs. Nowadays, I assume, we cannot imagine a father judging his son's conflict in rabbinic courts, like a woman. This, in the end. These views enable us to understand how it is that Jewish law was open to PAs that seemed to undermine basic norms that other systems of law would presumably not allow. These views also enable us to understand the following phenomena. Why do we find in later periods disagreements between the poskim regarding the validity of PAs that seem less far-reaching than the cases we found that the Tanaim allow, such as Neman al-Abba? For example, we find a disagreement as to the validity of a PA regarding the prohibition to conduct a hearing on Fridays, okay? The day on which people prepare for Shabbat. This is in order to ensure that the judge performs with equanimity. How can we explain the opinion maintaining that conducting a hearing on Fridays is forbidden, while the law allows the father to be a dayan, both cases under parties' procedural agreement? I propose that such opinion might hold two necessary presumptions. A, refusing the kind of PA doesn't cause such harm that should force us to confirm it, as happened with Neman al-Abba. B, the poskim who disagree as to the validity of a PA to conduct a hearing on Friday perceive this PA as striving to conduct the process under the roof of Din Torah. Otherwise, the PA would not have been in dispute just as Neman al-Abba. This poskim reject the PA since the prohibition against conducting a hearing on a Friday is not confined to the relations between the parties, it is directed to the dayan. We may now summarize Rabbi Yehuda's opinion in two principles. One, PAs that relates to the party's interest only do not raise any difficult from the contents aspect and should be valid. For example, PA accepting the father as one of a panel of judges, like the wife, like the woman, but still I assume a motivation of the legal system is needed. Again, in the period of the Mishnah, such a motivation existed. And second, in the case of PAs that do raise such difficulty, the solution proposed is for the parties to mutually undertake to accept the judge's opinion and thus to conduct a process that is not governed by Din Torah. This solves, for example, the problem of allowing the father to act alone as a singular judge. Understanding the opinions of Rabbi Meir and Chachamim in the Mishnah and Tosefta requires separate discussions.